Hello, everyone. We want to welcome you to Next Generation Food Labeling webinar that we at McGuireWoods are putting on. My name is Trent Taylor, and we're delighted that you have joined us for this webinar. We have a big crowd today, and we really thank you for your time. As you may or may not know, we do these webinars every so often to survey what is happening with food labeling and food labeling litigation, and what we expect to happen in the future. And we expect to do more of these going forward and try to even have some in-person ones in various cities as well. Before we get started, a couple of housekeeping matters. First of all, I encourage you to ask questions. There is at the very bottom, there is a tab that allows you to ask questions. And we encourage everyone to do so. We will try to answer as many as possible during our webinar. If we don't or we're not able to answer them, then we will contact you afterwards and try to the best of our ability to answer them. Something else, if you don't think of a question during this, but if you're like me, you think of a witty question or a great question 2 days later. And if you do that, feel free to email or call us, and we'll be happy to answer your question at that time as well. And then finally, from a housekeeping standpoint, after this webinar is over, we're going to send out an email asking for feedback. We would love any feedback you're able to offer, whether it's good or bad, because we want to hear from you on ways to improve this kind of webinar and the services we provide. So with that, let me start by with a quick advertisement about us. And we have a large team of lawyers here at McGuireWoods on the food and beverage team who devote much of their time to food and beverage issues and who know this area very, very well. And I wanted to mention a couple who were not able to join us today on this. Many of you probably know Jim Neal, who is one of the co-heads of the food and beverage team here. He was going to be a part of this. However, he's actually trying a case for a food and beverage client right now and was unable to join us. Also wanted to mention Molly White, who is in our Los Angeles office and who also has a lot of experience with food labeling as well. And here's a sort of a short list of some of the things we do in the food and beverage area. We don't do just litigation. We pretty much do it all, and pretty much every other day we get a call or email from a client asking us to review a label claim or asking for some advice on regulatory issues. And we provide guidance on what some of those risks are. We also deal with food safety issues, everything from drafting recall plans to defending clients in FDA and USDA investigations. And in addition to defending clients in litigation, we also handle a lot of pre-suit demand letters, have a good track record of avoiding litigation by convincing plaintiffs' lawyers not to file suit. So, bottom line, if you ever have any of these issues that you would like some assistance from us with, please do not hesitate to reach out to any of us at the McGuireWoods Food and Beverage team, either by email or call or any other way. So with that, let's get started with the content. I wanted to start with just letting you know what we plan to cover today. We have looked at most, if not all, of the food labeling cases filed and decisions rendered in this space in 2018 so that you don't have to. And we're going to try to give you a flavor, pun intended, of the types of cases we have seen. And then we're going to talk about what some of the most important of those cases are, some of the trends that we see that will have an impact in 2019, as well as touch on targets we see in 2019 and beyond, targets from the plaintiff's bar. And then lastly, we'll briefly touch on tips on how to avoid problems. So we're going to be moving pretty fast, lots of slides. We're not going to touch on everything in this PowerPoint, but we like to provide the case names so that if you want to find out more about a particular area or a particular case, then you have the ability to do that. So we're going to start with categories of food labeling claims in 2018. I wanted to briefly introduce our panel who's going to be helping us with this. First of all, we have Ben Abel in our Charlottesville office. He knows this area really, really well. really smart, lots of experience counseling clients on risk involved with various labeling claims. He also, in conjunction with Jim Neal and others on the food and beverage team, puts out a newsletter each month highlighting new cases that have been filed, trends, decisions in the food and beverage labeling litigation space. And we provide that for a modest fee, so if you have any interest in that, please let us know. And also want to introduce Frank Talbot and Eric Fleming, who are both in the room with me here today. They are in our Richmond office. They also are really smart and have lots of experience with both litigation and regulatory issues related to food and beverage labeling, as well as other products labeling. And I work with them daily on a lot of these labeling issues. So with that, we're going to start with 15 categories of food labeling claims that we have seen in 2018. Frank?
Hi, everyone. Thanks for joining us today. I'm going to start off with the healthy claims and just a couple of cases there. The first case being the Zamola versus Carrington Tea Company, where the court originally dismissed a claim for injunctive relief related to a statement that coconut oil was healthy because there was no evidence that plaintiff would repurchase the product if there was any additional information provided. But the plaintiff refiled an amended complaint. Again, the defendant moved to dismiss, but based on the Ninth Circuit's case of Davidson versus Kimberly-Clark, the Ninth Circuit held that consumers can seek injunctive relief related to these label claims if they allege that they might repurchase a product in the future, if the product was either reformulated or if new evidence was put forward backing those claims. The case ultimately was voluntarily dismissed after a mediation about a month ago. Levin versus Stremix Heritage Foods is a recently filed case in the Central District of California. It hasn't had any movement in terms of briefing yet, so we're still watching that, but that relates to claims for Kern's guava, apricot, and peach nectar beverages. Plaintiffs are alleging that because the products contain 31% or less of fruit juice that they're named for, and that the products convey that they're flavored with only natural ingredients. It's misleadingly labeled, and plaintiffs essentially say that the products are, quote, sugar water containing artificial flavoring. Again, that's just recently filed, so that's something that we are watching right now. Which leads into the sugar claims. So the first case on the list is the Hadley versus Kellogg case, in which the Northern District of California recently granted class certification for 3 classes of consumers who had purchased certain Kellogg products that were marketed as healthy when they contained added sugar. The court determined that it could be determined on a class-wide basis whether the sugar content was misleading, and the court pointed to certain label statements such as lightly sweetened and wholesome goodness and tied it to percentages of added sugar as to how that could be determined. The court did deny a couple of one class related to Nutri-Grain bars with that. So then Wilson versus Odwalla is the other case I want to highlight on this slide. That relates to a no sugar added claim on Odwalla juice. The court found that the claims didn't violate the Food and Drug and Cosmetic Act and relied heavily on the agency's interpretation of the phrasing of 100% juices. The agency had written a letter that determined that that beverages with 100% juices qualified for the no sugar added claim and was in line with the agency's regulatory scheme and therefore didn't violate the act. So a takeaway from that is that going to be relying a lot on FDA's interpretation, where there is some wiggle room in the statutory and regulatory schemes. Next, we'll have the standard of identity. The first case listed there, Lynch versus Tropicana Products, related to claims that the Tropicana Pure Premium Orange Juice was natural, but the plaintiffs argued that the product was actually flavored in a way that violated the FDA's standard of identity for pasteurized OJ. The citation that we have there is the denial of the class certification because the claims were based on the allegations that all the members of the proposed class thought the juice was pasteurized and therefore had to conform to the FDA standards. But the judge denied certification based on evidence that many of the potential class members never even noticed that pasteurized was on the label. And they're still in briefing on renewed class certification, but it's just recently been stayed. I think a lot of that raises the importance of what consumers may see on the labels when dealing with class certification issues. And then the Cohen versus East-West Tea, let case go forward on a question of fact whether or not kombucha contained live organisms. And then the Patain versus Nestle Waters concluded that federal law preempted claims that bottled water didn't meet the government's definition of spring water. So next, we'll look at the product testing claims. These four cases all contain claims within the complaint that plaintiffs or plaintiffs' experts had rigorously tested these products and that the products were found to contain or found to not contain what was stated on the labels. Kumar versus Salad North America related to extra virgin olive oil, and as it relates to the product testing claims, plaintiffs alleged that it was mixed with refined oil and packaged in clear bottles such that oxidization happened when it was exposed to light, and therefore it was not pure extra virgin olive oil. Ultimately, that case settled for 50 cents per consumer, which was recently affirmed in the Ninth Circuit. There was a second claim in there related to the statement that the olive oil was, quote, imported from Italy, and that was false because there were constituent olives that were grown around Europe and then shipped to Italy for processing before being shipped over. That was part of it as well. The Wong versus Trader Joe's related to some sour gummies, some Trader Joe brand sour gummies, and plaintiffs had alleged that they had done laboratory testing that demonstrated that DL malic acid was flavoring the gummies, and that although Trader Joe's advertising campaigns had marketed everything as all natural or with natural products, this DL malic acid was manufactured and not naturally occurring. That's been recently filed. There hasn't been a motion to dismiss or any sort of briefing on the issues, so that's just allegations at this point.
And one thing I'll add, this is Trent, we're going to be talking a lot about malic acid or malic acid today, and so this is sort of the first instance you've heard of it. The other thing I'll note about the product testing claims is it can be very difficult to win motions to dismiss in these cases because you have an allegation that they've done this testing that says X is not in the product, and the judge has to take that on its face at the motion to dismiss stage most of the time. So it can be very difficult to do this. So lots of times what you see defendants doing is trying to move for summary judgment early in the case, and even lots of times well before any motion for class certification, and sometimes just right off the bat.
Yeah, and I think that's a very good point, Trent. And so a lot of this will get into the deep expert issues and trying to dauber on other issues related to that. The Tide versus Walmart case, Ty versus Walmart and Robinson versus J.M. Smucker, again, were just cases with allegations of product testing showing that there was no pork in Walmart's Great Value pork and beans brand, and that the olive oil spray, extra virgin olive oil spray at issue in the J.M. Smucker case didn't actually contain extra virgin olive oil. So again, kind of same as Kumar and Wong. So next we have supply chain issues. These two cases relate to unfair and deceptive trade practices for chocolate, where the manufacturers had imported cocoa and other ingredients from West Africa, where plaintiffs allege that there's child and slave labor and other human rights violations generally. The Hodson case, the court found that California consumer protection laws don't impose these independent obligations on manufacturers to provide this sort of information. Plaintiffs wanted a label statement that this product was used and manufactured with ingredients from West Africa, where these violations occur. But the California court essentially said that you can't demand labeling information that is unrelated to the product's central function or advises for some safety hazard. And so the court dismissed the claims. And of note, part of the defeat was that Mars had complied with the California Transparency and Supply Chain Act, which requires disclosures not on the label of certain information related to combating human trafficking, slavery, and other concerns raised by these issues. Tomasella versus Hershey is a very similar case. It's currently pending in Massachusetts, brought by the same individuals. The diet cases for Becerra v. Dr. Pepper and Geffner versus the Coca-Cola Company, essentially both plaintiffs alleged that because the products contain the word diet, that they believe that drinking diet soda would help lead to healthy weight management or weight loss. Essentially, both courts tossed suits because they did not believe that the reasonable consumer would think that drinking a diet soda would lead to reduced weight loss or healthy weight management. Rather, it just comparatively contained less calories or less sugar as compared to regular Dr. Pepper and regular Coca-Cola.
Great. Next, we're going to talk about natural claims. Everyone's favorite claims. This is Ben Abel. Like Trent said, I'm an associate in our Charlottesville office, and the short and sweet is a natural is back, at least in a modified form. As I'm sure most people on the webinar know, when the FDA said that it was looking for comment on how it would define natural, there sort of became a self-imposed and often court-imposed stay and quiet period on a lot of these natural claims. And what we've seen in the past couple months is that natural claims have been making a comeback. It's pretty evident that the plaintiffs' bar has sat on their hands long enough with a lot of these natural claims, and so they've kind of repackaged them in a different way, and we'll talk about that as we go through both these natural claims and as well as our outlook for 2019. But to discuss the cases very briefly on the slide at the moment, Maxwell versus Unilever. This was a case involving alleged artificial ingredients in sodas, and this particular opinion was actually the plaintiff's third bite at this apple, and the court essentially part of this claim was that the plaintiff admitted that the ingredients that she alleged were artificial and not natural appeared in the ingredients list, and she also failed to plead reliance. And given that this was her third time around the block on this claim, I was dismissed with prejudice. The second is this Walmart claim which was not denied the motion to dismiss and went forward. Again, this was, as the slide shows, an all-natural claim related to enriched wheat flour. What I'll add is interesting about this case is in this one, the plaintiff bought his products online, and the ingredients list, apparently, at least according to the pleadings, the purchaser had to click through to another page to see the ingredients list, and the court didn't buy Walmart's argument on the motion to dismiss that, well, simply because the ingredients list was on the website, that was enough to defeat the claim. So as we move into an increasingly digital and e-commerce world, I think that's a case and an opinion as we go forward that clients will want to watch for the, if nothing else, for the e-commerce aspects about that. And then there still are a lot of stays pending out there when it comes to natural claims. Judges seem to be getting increasingly grumpy about the fact that this stuff is sitting around on their 6-month reports. There was another case involving Kind bars, both with GMO and natural claims, that was stayed earlier in the year, where the court essentially said it was not happy about the fact that it was continuing to stay, but it was going to continue to stay. Some additional natural claims include natural claims involving animal products. The first of these is the Dannon case, and we got a request in our question and answer that we, to the best of our ability, try to include some information that would be relevant to restaurants as well as packaged food providers. This is a type of claim involving GMOs that we actually also saw break into the restaurant space. A plaintiff in Georgia, I believe, sued Chipotle, saying a similar claim that not that the beef itself was GMO, but that the feed that was given to the cows that then made the cheese and made the sour cream, for instance, that feed was genetically modified. And that claim was dismissed. And that dismissal was upheld by the 11th Circuit. But so we've seen this particular flavor of this natural claim break into the restaurant world as well. This is one that we think will likely be dealt with if and when the bioengineering standards are finalized, but it's a claim that's out there. And then the Sanderson Farms claims, again, dealt with natural as it went to chicken. And what's interesting about this case is this is a case where the plaintiff organization sued not only on the label but on the marketing surrounding it, and the court essentially said the marketing went far beyond what was pre-approved by the USDA with the label, and so the claim went ahead. So that's another reminder for clients and for manufacturers that just because you've gotten pre-approval or just because something on the label might be okay, claims that are made elsewhere in marketing could expose you to liability or potential liability. Preservative-free, this is kind of the next round of how we're seeing natural claims be brought, are these claims that are relating to preservatives or are related to ascorbic citric acids. These cases up here speak for themselves, but I will tell you, as Trent said, we track cases on a month-by-month basis, and I think last month we saw 20-something claims, and if not the majority, the lion's share of those were these preservative-type claims. It's an incredibly easy claim, I think, for the plaintiff's bar to make, and frankly, a lot of what we saw last month, was relatively cookie-cutter complaints. And so this is definitely one, to the extent that, and we'll talk more in our outlook about malic, citric, and ascorbic acids as something to watch in 2019. But these preservative claims are definitely something that should be on your radar to the extent they aren't already. Next, we'll move into country of origin and region of origin claims. We saw what we thought was an uptick in these last year, and they took a variety of different forms. So the first of these is a suit alleging that Cascadian Farms frozen fruits and vegetables don't actually, at least according to the complaint, come from Washington State despite Cascadian in their name. And so there was a deceptive labeling claim that resulted from that. This same claim plaintiff, we saw brought a claim that survived a motion to dismiss against 21st Amendment Brewery. Don't know if you know some of their beers. They're a relatively small brewery. But on their box, they had a map that said, come visit us in the Bay Area in California. But some of their beer was actually brewed in Minnesota. And so as a result, the court held, at least at the motion to dismiss stage, that the packaging saying, come visit us in California, was deceptive. And most people on the call probably know the Kona beer case that's out there about origin of where Kona beer not actually brewed in Hawaii. So this is another type of those claims. That hit large firms and small firms just the same. And there was another case last year that survived partially a motion to dismiss based on statements that Guinness in North America, all the Guinness in North America essentially was brewed in Ireland, when in fact some of the Guinness sold in the United States was brewed in Canada. And in that case, the District of Massachusetts said claims on the label itself were approved by the TTB, and so it held they were precluded. But statements again that were on the website regarding where the beer in North America, Guinness beer in North America, had been brewed was not preempted by the TTB because it hadn't been pre-approved. And so again, any e-commerce or electronic advertising that you do is something you need to be mindful. And then there were a series of olive oil imported from Italy settlements last year that hit companies like Safeway and brands like Bertolli. And so those were claims that the olive oil said it was imported from Italy, but the allegation was that the olives didn't all come from Italy. A couple other country of origin, region of origin things to keep in mind from last year. Of course, if you're USDA regulated, beef and pork do not have country of origin labeling as a result of litigation with the World Trade Organization. Other meats and products regulated by the USDA, check your regulation. And the U.S. Cattlemen's Association, I believe, if I remember correctly, sued in the Western District of Washington, alleging that the United States government, USDA, needed to reinstate cool for beef and pork, and that was dismissed on a motion to dismiss. So that was unsuccessful. So still at this time, USDA is not enforcing cool regulations to beef and pork. Next, I just want to talk very briefly about clean labeling. I was at a conference at the end of October with labelers, and this was something that is keeping them up at night. Is how do we deal with and how do we make sure that we're doing it correctly when it comes to the push for clean labeling? And to the extent that clean labeling kind of is a catch-all for a panacea of a bunch of different things that the consumers would like to see in labeling, I wanted to call out one specific type of case we're seeing here in these three cases that are on the deck, on the slide, bear out these are cases where each of these products, at least according to the allegation, has on the front of the package really basic labels. And if anyone from Chicago Bar, for instance, RX Bar, is on the call, I'm not looking at a label, but they'll say something like includes 3 eggs and 8 blueberries and 1 apple. And that has opened companies with that kind of labeling up to claims alleging that when you say you have 1 apple in your product, I, consumer, think that means that there was 1 apple that was in this from start to finish, not that the product is made from apple purees or apple concentrate, something of that nature. And so these claims have resulted from consumers at least saying, when you say apple, I think you mean apple. And so the takeaway, I think, being that you want to make sure that when you have a label like that, that the front of the package matches the back of the package, and you're not giving a false impression, or at least allegedly giving a false impression, that something's in the product in a whole form that isn't. Wanted to talk about water claims. There were a bunch of water claims last year on a bunch of different varieties. So those started with the top case there, which alleged that gemstones that were in water and went for an exorbitant amount of money per bottle. There was an allegation that not only did the gemstones do nothing to help the water and provide any health benefits, but also that the gemstones were encapsulated in a glass container within the bottle of water, and there couldn't even interact with the water. Another type we saw was the second suit, the Kennedy suit, alleging that claims related to superhydration involved in the water were deceptive because, at least according to the plaintiff, water is water and it can't hydrate you any more than any other kind of water. And then we saw a series of suits related to alkaline waters, which is, I think, a growing area in food and beverage law. And so 7-Eleven, for instance, was sued regarding its alkaline waters, the allegation being that the producers misrepresented the health benefits of the waters. And we just this month, in a similar suit that was filed against Trader Joe's, the court dismissed on a motion to dismiss that claim, and basically said that any claims that the plaintiff pointed to, at least in that case, were essentially puffery, and that as long as the defendant could point to elevated pH in the water and otherwise didn't make any health claims that were incorrect, that the marketing is the marketing, but as long as they say the pH is increased and it'll hydrate you, that didn't survive a motion to dismiss. So if you remember in our beer cases, the Peacock plaintiff, he also filed suit against Olympia Beer, alleging that their natural spring water that was a part of their marketing used it to brew the beer actually came from a municipality in California and not in Olympia, Washington. So Mr. Peacock, while being busy, also filed suit in the water area as well. And finally, I will talk very briefly about Prop 65, which is another thing that obviously producers are very concerned about. And I'll start with the ongoing saga as it comes to coffee in California. The very brief version being Prop 65, for those who don't know, anything that contains either carcinogen or could produce birth defects in California needs to have a warning on it if it's sold in California. There's a suit pending, the Council for Education against Starbucks suit, that coffee, when it's roasted, produces something called acrylamide. It's part of the roasting process. Acrylamide is listed as a carcinogen. And so the plaintiff organization there filed suit saying you, basically everyone who sells coffee in California, have not been providing the requisite Prop 65 label. The FDA got involved in this one, saying that actually it thinks that there shouldn't be a Prop 65 label, a label for coffee because coffee actually has health benefits. And went back and forth, and it looked like the state court judge was going to require coffee sellers to have the Prop 65 warning, and then the regulatory agency within California itself stepped in with a proposed rule saying that coffee did not have to carry a Prop 65 a warning. A couple other very quick ones is cereal. Healthy cereals need not include a Prop 65 warning. The court held that was preempted based on the federal government's belief that we should be promoting healthy foods, and so anything that would keep people from buying healthy cereals, including a Prop 65 warning, was preempted. And I'll skip down to the bottom. There is a federal court enjoined California from listing glyphosate, the ingredient in Roundup, the weed killer, and we'll talk at length about glyphosate towards the end of the presentation, but enjoined California from listing it on Prop 65, saying it didn't have the evidence to support it being listed as a carcinogen on Prop 65. And that case, I think, really going forward is going to provide the blueprint for a lot of affected industry members who have Prop 65 or potential Prop 65 products to fight back against being put on the Prop 65 list. It was a successful strategy, at least in the short term, in getting a preliminary injunction. So, with that, I will turn it over to the next presenter.
Hey everybody, this is Eric Fleming in Richmond. Wanted to talk about a few more categories. First off, claims that products include fresh ingredients or are fresh themselves. There are two cases I wanted to talk about. They both highlight slightly different things in this area. First off is Campbell Beef Fresh Bev. This is really about what it means to be fresh in the court's mind. Basically, Fresh Bev uses high-pressure processing to stabilize its beverages. It's different than pasteurization, and in fact, the plaintiffs tried to claim that they failed to disclose that their product was pasteurized, but that claim was preempted. But the court did not dismiss claim that the product was misleadingly labeled as fresh, relying on federal regulations, particularly 21 CFR 101.95. Court noted that FDA thinks that fresh generally means in its raw state, hasn't been frozen or subjected to any form of thermal processing or any other form of preservation. Since HPP would fall under that sort of rubric in the court's mind, the court decided that declined to dismiss claims that the fresh label itself was misleading. The other case on this slide, Reyes v. Crystal Farms, this is recently filed. I don't think there's been any sort of movement in terms of briefing, but just sort of the general allegation here is that the product claims on its label that it's made with fresh whole potatoes, but the product itself, the final product, includes some preservatives to extend the shelf life out from about 3 months, whereas according to the complaint, potatoes have a stable shelf life of like 7 to 10 days. So the gist of the allegations here is that a final product that is made with ingredients that were fresh when they were processed, but the final processed product includes preservatives to extend the shelf life, is no longer falls within that definition of fresh and is therefore misleading. That's something that I imagine is going to be relevant to everyone. I mean, if you're using all ingredients or many ingredients are to some extent fresh, but a lot of folks need to, extend the shelf life out to keep the product shelf stable. So that's something that we're going to continue watching as it develops. Moving on to the next area, ingredients and flavoring. So ingredients claims are label related, but in a lot of cases, the cases can also be decided without reference to the label at all. And so I picked these two cases for the slide because I think they highlight that. The first of these cases, Feldman v. Utz Quality, I looked at the docket for this morning, and there's enough sort of weird notations by the clerk indicating that things were misfiled that maybe Utz isn't worried about this and maybe they shouldn't be. But generally, the gist of their complaint is that Utz was manufacturing their products with one set of ingredients, switched to a cheaper synthetic set of ingredients, and the vignettes and nutritional content claims on the front of the label are no longer true and are misleading as a result. So that's a claim where the ingredient switch relates to what's on the label, but I also included 100% grated Parmesan cheese, MDL, because that's one where actually the claim is, it looks like the case is going to survive irrespective of the court's conclusion that the labels are not misleading in themselves. Basically, the gist of this case, I'm sure everyone's followed this at least a little bit, a bunch of canisters of grated Parmesan cheese say on the front that they are 100% grated Parmesan cheese. But the products also include an anti-clumping agent, cellulose, which plaintiffs are claiming is made from wood pulp. The gist of the labeling claim there was that the 100% grated Parmesan cheese was inherently false because there were other ingredients in the canister that were not disclosed on the front but were part of the ingredient list. Judge Fenner didn't like that argument. Because if you go to the ingredient list, there are at least 2 ingredients on there, so none of them can be 100% of anything. Regardless of that, so you'd think the case would be over if he's dismissed these labeling claims for a while, but I think this is the third time that he's dismissed it, second or third. Case isn't over because the unjust enrichment claims are going to survive based on what ultimately is just a straightforward application of economic adulteration looks like. Okay, next, wanted to talk about the GMO claims. There are two cases here that I wanted to discuss. So Schneider v. Chipotle is sort of the counterweight to the Georgia case that Ben brought up. Again, same fact pattern. The cows and the chickens are all fed GMO feed. Chipotle is saying that they sell non-GMO products. The court here, unlike the Georgia court, has actually ruled against, denied motion for summary judgment and has certified 3 classes. Am I still on? Okay, certified 3 classes. That's currently under appeal. Sort of the thing that interests me about that is that the National Bioengineered Food Disclosure Standard doesn't reach restaurants, and it doesn't require disclosures for animals that are fed GMO foods. So this is sort of outside of that rubric. Another case sort of similar. We got this. Nestle is also alleged to have used milk from cows fed non-GMO feed, and that case has got some extra dimensions in there that look a little bit more like trademark violations, which is kind of interesting and worth sort of watching. Moving on to real claims. This is like an ingredient claim, but it's much more closely tied to what's on the label. First one of these is a recently filed case where Crystal Farms is alleged to sell a product where the claim is that the mashed potatoes are made with real butter. The plaintiff's complaint is that the product also contains margarine. I'm interested to see where this case goes because they actually admit that the label statement is technically true. There is real butter. It's the second ingredient on the label, but they're also saying that there are other ingredients. And then the Dr. Pepper claim, obviously, we're all familiar with those, whether it's real ginger if it's made in the lab.
Fantastic. So that's the categories of cases we have seen in 2018. I think they provide you a sense of what's out there right now. We also have a number of cases in our slide deck, the most important cases from 2018, and I believe we have 7 of those. We're not actually going to go through them in the interest of time right now, but I encourage you to pay particular attention to these. I think we're probably going to allude to a couple of these later on in our presentation. But we're going to move directly now to the trends for 2019. And give me just a moment to get to the right slide. And we're going to start with an overview of what we think will happen in 2019, and based on what we've seen in 2018. So, a lot of times I think we get through a tunnel vision and we pay attention to a couple, particular cases that we're involved with. We want to give you a broad overview. We want to give you the forest rather than the trees. So, right now, in 2018, there have been more food labeling cases filed than in 2017, which frankly is a little surprising because with uncertainty on natural and pending possible FDA guidance on that coming forward, I think a lot of us thought that maybe some of these cases would slow down to a certain extent. They really haven't. We're seeing more cases filed than last year, number one. Number two, those in the food and beverage industry have gotten more sophisticated. They know the plaintiff's bar's tricks to a certain degree. They know what they're after, and so they've made changes, which makes it harder for the plaintiff's bar to find meaty cases, unintended, to go after. So the low-hanging fruit is mostly gone, and what we're seeing is claims that are either Hail Marys, desperate claims, or more in the weeds, more technical claims. And we're going to talk about that in a little bit more detail later, but with cases like the Hawkins case, which was in the most important cases of 2018, which was a recent Ninth Circuit decision, which basically said that if just because you have something on the front label, such as 0 grams trans fat per serving, even if that's allowed under FDA guidance on the nutrition facts panel on the back label, that doesn't mean that you can put it on the front label if you're rounding down. So it's a very technical point, but the Ninth Circuit sided with the plaintiff's bar on that. And I think that's going to fuel more technical claims and more litigation alongside those technical claims. Something else real quick. For the longest time, the Northern District of California has been known as the food court because there have been so many food labeling cases filed there. We're starting to see, and we've seen this over time, but we're really getting to a point now to where there are almost as many cases filed in New York as there are in California. We've seen a lot of cases filed in the Southern District of New York and the Eastern District of New York especially. And we expect to see more of those going forward. We're also seeing a lot more cases filed in the Southern District of California as opposed to the Northern District of California. We're going to talk a little bit about the malic acid cases here in a bit, and we're seeing a lot of those filed in the Southern District of California. And the last point I'll make on this slide, and Ben may want to add something as well, is, and this really goes to the first point about the low-hanging fruit is gone and seeing either Hail Mary or more in the weeds cases, is we're seeing more courts dismiss claims at the motion to dismiss stage. And that may be in part because of the reasonable consumer standard. We're going to talk about that here in a few moments, being something that judges and courts are latching on to a greater extent than in the past. But we're seeing, I think I saw almost as many motions to dismiss granted completely or in part versus motions to dismiss that were completely denied, which is pretty rare in this area. So that's great news. The bad news, though, is that there are more motions for class certification granted than compared with denials in the past. Now, it's taken a lot longer for these cases to get to the class cert stage, but when they get there, we saw, I think, 5 times as many class cert motions granted this year versus those that were denied. So bad news there, something to pay close attention to. Ben, I don't know if you want to add something on that, and
Sure.
I know you have the next slide as well. So.
Sure. Yeah, I just wanted to add, Trent mentioned that we're seeing a lot more litigation in the Eastern and Southern Districts of New York. I also wanted to add, I think traditionally you think of kind of getting the third place bronze medal of where we see a lot of cases filed will be down in Florida. And we're seeing a trend of a lot more cases being filed in Illinois and Missouri as well, specifically in the Western District of Missouri. And the reasons for that, I don't know if plaintiff's bar thinks that they've got some good consumer protection law in those jurisdictions or good judges or what, but I think increasingly, not that Florida still doesn't see its fair share of filings, but as people who might be responding to litigation, I think being prepared to respond to litigation in Illinois and in Missouri will be a smart things to prepare for. Our second trend we wanted to talk about, and I'll go quickly, is the death or at least a reining in of slack-fill litigation. Slack-fill to start 2018 was a massive area. We saw a lot of cases being filed in the slack-fill area. Again, an allegation, slack-fill being non-functional space within the packaging that's empty and doesn't fit into a regulatory category for the reason for having that space, hence why it's not functional. There were a couple settlements in this area that we thought were potentially going to attract more attention in this space. There are a couple settlements in the $1 million range, but since then, we've seen cert denials in slack-fill litigation, including, like I said, in the Western District of Missouri. And we saw the decision in the Tootsie Roll case as it related to junior mints that basically the court wasn't going to hold the plaintiff's hands, that the plaintiffs knew what they were buying at the time that they bought the products. And again, for our friends in the restaurant world, slack-fill extended into the restaurant space with a couple suits filed against Starbucks, one alleging when you ordered iced coffee, that the allegation was I expect to get 12 ounces of coffee. Another alleging when I order a latte, I expect the cup to be filled to the brim with with coffee and not with milk foam. And the court in both of those was pretty darn unfriendly to the claim that those slack fill, as it were, if they weren't technical slack fill cases, were poorly received by the courts. The next I want to talk about is the evolution of natural claims. As we stated, natural is back at least in a hybrid form, and it's really back when it comes to these, in addition to the cases we discussed earlier, it's back in these malic acid, ascorbic acid, citric acid cases that are alleging that preservatives are in this product or that this is artificially flavored. A lot are alleging that malic acid or another type of acid is used to imitate fruit flavors in products. So just recently we saw, this past week, we saw cert in a suit against Ocean Spray related to malic and fumaric acids. So these claims are succeeding, at least getting past to the cert stage. And so when we see natural claims going forward, and I'm looking at the stack of claims filed last month for our labeling update, they are back, but they are taking the form of these no preservative malic acid, ascorbic acid cases as opposed to just a pure GMO claim or something like that.
Okay, well, thanks, Ben. I wanted to briefly touch on, I know we're running out of time, so we'll move quickly. There's always so much to talk about. We love talking about this stuff, and sometimes we get a little carried away. But one of the things that I alluded to earlier was the re-emergence of the reasonable consumer standard. And that's essentially where courts are dismissing some of what we would think are the sillier claims, the Hail Mary claims, at the motion to dismiss stage by saying it's not plausible that a reasonable consumer would think that, and they're dismissing it. And that's a very, very, very welcome trend. In the past, a lot of these courts wanted to do that, but they would say, no, it's the pleading stage, we're going to let it go. But a lot more courts are more willing to do that, and we have some cases here, and I'm not going to go through them other than I love the one about the McDonald's extra value meal. And basically it was an allegation against McDonald's saying, well, they have this extra value meal, but when you actually look at the price, if you bought them separately, it'd be the same price. So therefore it's not value. And the court said, well, understandably, plaintiff may not have wished to take the time to compare prices, but if they had done so, it would have dispelled the quote-unquote deception on which her claims are based. So good news there. We also have a couple of other claims. We have one claim that just came out yesterday, which from the Second Circuit, which affirmed the dismissal of a class action alleging truffle oil doesn't contain truffles. The allegation there was centered on truffle flavored. So that's a welcome case as well. And then finally, the last trend that I'll talk about before we go into some of the targets are ingredients. We've already talked about this to a certain degree about the ingredient litigation. And this is really where we see a big area for plaintiffs' counsel. They are going after ingredients. They're going after cases where there are less expensive ingredients. For instance, there was a case that was filed earlier this year against a salad dressing, and it basically targeted the fact that it contained soybean and canola oil, which are less expensive than olive oil. And it was called olive oil dressing. It had olive oil in it, just as not as much as the plaintiff or the consumer would have liked. So they're going after less expensive ingredients. We're seeing that. We're also seeing going after natural and artificial flavors. So there's a situation, there was a case filed in federal court in Massachusetts earlier this year. It was hazelnut cream coffee. and it contains exactly what the FDA says you're supposed to have, which is contains natural and artificial flavors. But the allegation there was that it's artificially flavored and contains no hazelnuts, and therefore it's deceptive. Now, this is very similar to that case I just mentioned a while ago that the Second Circuit affirmed the dismissal of, but we're seeing more and more of those types of cases, and that might gain a foothold at some point. Now, let's talk about some of the targets that we're seeing right now, and we're going to move pretty quickly through this. One of the really big ones right now is glyphosate, and I know that's something Ben mentioned earlier, which is the chemical in Roundup. And the reason why it's really big is, I'm sure most folks are aware, that there was a $289 million jury verdict earlier this year related to Roundup. Now, that wasn't in foods, but we're seeing enterprising plaintiffs' lawyers, I'm being charitable there, they see money, and they're going to go after food companies, and they already have. We've seen double-digit, over 10 suits now filed against food and pet food manufacturers based on having very low levels of glyphosate in the food. Now, these are all in the very early stage, and we don't know what's going to happen with them, but if they get any traction at all, I think we're going to see an explosion of cases related to glyphosate. In addition, we're seeing chemicals other than glyphosate. So, for instance, there's one, and I'm going to mispronounce this, but it involves applesauce and apple juice containing trace amounts of acetaminoprid. Actually, I think I did pretty well with that, which is used to treat and harvest crops. So we're seeing a lot of other claims targeting food that may contain trace amounts of chemicals, whether they're pesticides or fertilizers or other things. So that's something that we need, and I think everyone should be paying close attention to. Environmentally friendly is another one. We're seeing suits that are targeting claims such as coffee pods labeled as 100% compostable and environmentally friendly. And that was actually filed in state court in the Kansas City area, which is, I think, what Ben was alluding to in the Western District of Missouri, in state court there. And they're claiming that it's really not compostable in commercial. It's only compostable in commercial compostable facilities, which are not generally available in Missouri. We're also seeing similar type targets on claims of environmentally friendly. Some see that with like Ben & Jerry's ice cream, that kind of thing. Briefly touch on a couple of other ones. Ben talked about malic acid and sort of the morphing of natural claims. This is a really hot area right now as well. And it's hot because they are getting traction. We had the first one of these, and Ben alluded to it a few minutes ago, get certified as a class last week, the first malic acid case. And they are surviving motions to dismiss and now getting certified as classes. And we're seeing targets such as citric acid and ascorbic acid and other types of claims as well, or other types of ingredients as well, that used to were not seen as artificial at all. So that's something to pay attention to, and we think that we're going to see plaintiffs go after other ingredients. And one that we sometimes get questions on is maltodextrin and other similar type ingredients. So if you have any ingredients on there, on your ingredient list that are have the possibility of being synthetic, then you should pay very close attention to that and very close attention to natural and artificial preservative claims. I'm going to skip over a couple of other of these because we've already talked about them. There's the clean label. We've already talked about that. There's the real fruit. Is it real fruit or is it real fruit puree? And we saw the one with Fitzhenry and the made with real ginger case. Those are surviving. And so if you have a made with real whatever on your front label of your product, that's like a red flag waving in front of a bull right now with the Plaintiffs' Council, because the plaintiff's bar, because they are very interested in that particular one, and you need to make absolutely certain that you are protected and that that claim is 100% accurate, or else there's going to be a lawsuit. We've talked about origin. We're seeing a lot of those, not just country of origin, but also state of origin, such as, Hawaii chips that are not actually made in Hawaii. Even though it doesn't say made in Hawaii, if you have imagery on your packaging that suggests that it might be made in Hawaii, such as hula dancers on it or surfboards or that kind of thing, then you might get sued. And we're seeing a lot of those right now. And then finally, and we already talked about the health halo effect. The health halo effect is the first most important case of the year, which was the Hadley case. It was referenced in that one. It was class cert was recently granted in that case. It was basically against a manufacturer of cereals, and the claim was that there was a general sense that this product was healthy, despite the fact that it contained what the plaintiffs believe were too much sugar. So that was recently certified as a class, and frankly, that case there's a lot of fear out there about that case, the Hadley case. And so because that class was certified, we expect to see more of these types of cases being filed in 2019. And with that, we are done with the content other than the tips. We have some tips here. We're not going to go through them because we're already over. But the tips here are the type of advice that we give to a lot of our clients. Make sure you have evidence backing up your claims and nutritionals. Be careful with natural or no artificial preservatives. If you have any borderline ingredients such as malic acid, maltodextrin, fumaric acid, those kinds of things. And then we have certain products to be aware of. We see a lot more suits targeting juices, energy drinks, Kumbaka, which is not something I drink because I clearly mispronounced it, energy bars, and cereals. Lastly, I wanted to talk about a couple of things, a couple of questions that we received. I know that we received a question about how some of these cases get filed, whether they're consumer complaints or something else. And that's a really good question, and it's something where I think a lot of plaintiffs in these types of suits are recruited by the Plaintiffs' Counsel. Sometimes it's ads, sometimes it's friends and neighbors. But if you're litigating these types of suits, that is something to investigate because it can be a very fruitful, pun intended, avenue to explore in this type of litigation because they have lots of problems finding consumers of these products to use as plaintiffs. And then there have been some questions about like whether ascorbic acid and citric acid and some of those types of things are artificial, which is a really good question, and it's the bottom line is it depends. Some of these ingredients act in certain ways, and sometimes they act as flavors or preservatives. Sometimes they don't. So it depends on what the food product is to a certain extent. It also depends on whether they're naturally occurring, ascorbic acid or citric acid or malic acid, or whether they're synthetic. And so a lot of these malic acid suits are targeting them because it's synthetic malic acid that is made in a lab as opposed to naturally occurring malic acid. So I think that's probably all the time we have for now. I want to thank everyone for being a part of this. I'm sure there are some questions that we missed, and we will get back to you as soon as we possibly can with answers to those questions. And feel free to email us or call us at any point, and we are happy to talk about anything. Before I shut this down, I'll see if Ben has anything he wants to add before we conclude this.
I don't, but I think Heather wanted us to let everyone know that a copy of the presentation will be sent out no later than early next week to everyone who registered for the webinar today. So the stuff we went over or skipped to make sure we stayed relatively on time will all be in there, and we look forward to hearing back from everyone with any questions or comments. And again, thanks so much for joining us.
Yeah, thank you.